Okay, Peter Sankoff, thank you for coming on to the show. Peter, your list of accolades and accomplishments is very impressive and long. But just to give people an idea of your experience and background, I just wanted to go over some of those accomplishments. We could probably spend a couple hours going over them. But you're a graduate of the University of Toronto. You got your JD there. You worked as a clerk for Madam Justice, and excuse my butchering of this name, but Madam Justice Leroux Dubé.
L'heureux du Bay, yeah,
Yeah,
that's
yeah.
correct.
I'm learning as I do this podcast how bad I am at pronouncing names. And you got your LLM from Osgoode Hall, and you also worked at the Department of Justice. You're now a law professor at the University of Alberta. You've been there since 2012. You've been teaching for 20 plus years in the areas of criminal law, evidence, animals in the law, and constitutional law. You've taught overseas in a number of different countries. You're also, outside of your teaching, you're also counsel at Bottos Law Group, which focuses on litigating cases in Alberta's Court of Appeal and Supreme Court of Canada. You appeared in front of the Supreme Court of Canada. In addition to all of these accomplishments, you're also a prolific writer. You've co-authored 8 law books, and you are the author of many scholarly articles. Your chosen topics include criminal procedure, Charter of Rights and Freedoms, jury, future of teaching and education in law school, animals, and the law. Many of these articles have been mentioned in numerous court decisions throughout our country. Your list of awards are many, but to name a few, you've been voted as a top 25 most influential lawyer in Canada in government and nonprofit category by Canadian Lawyer magazine for 2020, and you've been nominated by that magazine in past year for your influential and important work. And you are the co-host of a popular and excellent podcast called Paw and Order, which explores animal law issues. And this show has also won an award for Best Podcast. You also have a fantastic website, petersankoff.com, with a lot of award-winning content and material on there, especially the video blogs, Peter. I've really enjoyed listening to some of your topics and conversations of complex legal issues. And I saw on your website that one of your goals is to make the law more accessible for students and lawyers and the public. And certainly that's the aim of this podcast. So we really appreciate you coming on to the show.
It's my pleasure to be here. The list of accolades is what happens when you get really old. You just start to pile them up. That's the way this works. When I was younger, I don't think I was any less competent. I hadn't been around long enough to pick up all those awards.
Right. Well, it certainly is impressive, and I've enjoyed reading many of your articles. I have a special interest in animal law as well. But the topic we're here to talk about today, that you've graciously given some of your time for, is to discuss juries in Canada. And the case that we're focusing on, Peter, for the first season is the case of Peter Beckett, who has had 2 jury trials here in British Columbia. And I thought what we could do is just discuss juries generally and then get into more specifics. And you've written a couple articles that are fascinating related to juries. There's this idea in Canada, and you correct me if I'm wrong or you disagree, but that the jury is this kind of revered institution. It's enshrined in our charter. And it has kind of a special place in our justice system. And I'm wondering if you have any thoughts of the historical context of this.
Well, I have a lot of thoughts on juries, as you know from my writing, and I have gone back and forth on the value of juries as an institution over my 20 years in practice, which is not surprising because it's such an important and core institution in Canadian criminal justice. And when you look at it, you see a lot of pros and cons, and that is at the core of the tension that people feel around juries, is that there are unquestionably benefits and there are unquestionably costs. So this is not, I don't think there is literally anyone you would find in any part of the justice system who would say unilaterally juries are 100% awesome, there's nothing wrong with them, or conversely, unilaterally, they're the devil, there's nothing good about them. I don't think that's possible, because I actually think that no matter how you slice it, juries are a mixture of benefits and disadvantages. And your view about juries sort of depends upon which of those benefits or disadvantages you think are most important. So just to pick one out of thin air, if you are an economist and you think that we should do criminal justice in the most efficient way possible, you will be anti-jury. That is just the nature of the beast. Juries are extremely costly. They add all sorts of direct and indirect costs to criminal justice. So just on a cost benefit, that is not going to be something that matters to you. If you are sort of more of a fundamental theorist who believes that the people need to have a say in this, and that giving things away to unelected officials to make decisions is problematic, you're going to be pro-jury because you believe conceptually that the jury represents the people's ability to participate in a system. So by and large, and those are not the only values at play. What the values that come into play are going to depend upon what you bring as an observer to the system. So the love-hate jury thing is really an amazing thing to behold, and it really differs depending upon which values you believe are more important. I myself tend to sit towards the middle of the spectrum, in that I believe there are pros and cons. But I mean, I think if you push me, I tend towards more in favor of juries. That said, I believe the way in which we address juries is not necessarily the most efficient, and that could take a whole other podcast to get into. But I think there are flaws in our system that make the jury system less useful than it could possibly be. But the final thing I'll say just on this introductory point is, in one of my articles, what bothers me the most about the jury system is the fact that the jury system is unassailable. It is quite literally the only aspect of criminal justice that you will need a constitutional amendment to repair. And that is exceptionally strange. It's exceptionally strange to me that there are just, if you look around what's going on in criminal justice and you think about the procedures that have changed over the centuries, you can look at things like preliminary inquiries, grand juries, if you went to the US route, the way in which we sentence people, the representation of the Crown versus the accused or third-party interests, the rise or the demise of private prosecutions, things that hundreds of years ago would have looked absolutely fundamental to our system of justice. And the truth is, those can all be reformed. But to reform the jury, you need a constitutional amendment, because Section 11F of the Charter makes the jury process a constitutional right. And not only does it make the process a right, what concerns me more is that is the only section in the Charter of Rights and Freedoms, leaving aside some of the democratic freedoms that don't concern us, that actually sets the procedural way in which the right is activated by setting a punishment threshold for the jury in the Constitution, a 5-year punishment threshold by which your right to jury is achieved. And what I would say about that is, that is not like the point of this particular episode, but I will say that it is weird to have a constitutional document that was drafted in 1982 become the driver in a lot of ways of other policies, including the way in which we sentence people. It is literally a driver of that because there is a specified threshold in the Charter that activates the right. And I am not convinced. In fact, to the contrary, I am convinced that that was a bad idea. Even if you fervently believe in the jury as a form of Canadian criminal justice, or like me, even if you tend towards the jury as being a positive thing, I'm not convinced that it was a good idea to enshrine it in the Constitution, because changing the Constitution is exceptionally difficult.
Right. And that's what you discussed in your article from 2008, Rewriting the Canadian Charter of Rights and Freedoms, 4 suggestions designed to promote a fair trial evidentiary process. And in that article, I did want to discuss the enshrining this right in the Charter, because that was one of the suggestions in your article, is that potentially it would be a reasonable thing if you could remove it from the Charter. That would be a potential benefit to an accused and to just our justice system in general. And I'm wondering, Peter, if you have any idea why this right was included in the Charter.
I haven't done that sort of research, so I don't know exactly why it was included, but it's not too hard to understand the basis. It's always been, I mean, the right to trial by jury has been a long held right, and it has been part of our system of justice now for hundreds of years. So it's not surprising that it was regarded as a fundamental process. The thing that's troublesome about it is that when it was enacted, like it's really difficult to envisage what's going to happen years into the future. Like it's really difficult to envisage the way in which our methods of investigation and prosecution and thinking about criminal justice are going to change. So, for example, when you have rights that say, well, you have the right against unreasonable search and seizure, well, that's, a lot of people find that's problematic because it's malleable. But at the same time, it allows the courts to recognize in 2020, well, wait a minute, we didn't have cell phones in 1982, so we need to evolve our thinking about this to deal with cell phones, whatever. Well, with juries, it doesn't work that way. Like, it is true that we could argue about the components of the jury as a way of thinking about criminal justice. But the problem with setting a jury and setting a threshold, most particularly, I'm more troubled by the threshold than I am by the jury principle. I believe that the 5-year jury threshold has been really detrimental for sentencing policy. And I don't think it was designed that way. But the 5-year threshold drives everything. It's suddenly, well, okay, the real question in setting out sentencing policy is, do you want to trigger a right to a jury trial or not? Which has, really caused the way in which the summary conviction proceeding procedure has changed over time as Parliament recognizes the wisdom of avoiding jury trials whenever it can. So, like, in an indirect way, the right to a trial by jury has arguably helped set up a system in which punishments for summary conviction offenses and, quite frankly, offenses in provinces are likely to rise to the 5-year maximum. Like, if you ask me right now, what would you foresee 100 years from now? Well, right now, summary conviction offenses are punishable by up to 2 years. I think it's inevitable that will rise to 5. And I think the reason for it rising to 5 has more to do with the right to trial by jury than anything else.
And you mentioned the detrimental to sentencing aspect of it, and how the charter right, section 11F, very specifically says a right to a jury, with basically setting up the most serious of crimes. And I'm wondering, in your article, you discuss why a jury is most appropriate for what are often the more complex and difficult cases to, as a trier of fact, to really understand and render a just verdict in.
Yeah, that's right. I mean, I think the 5-year threshold is problematic for a number of reasons. In part because it's so arbitrary. It's like a defining characteristic of what's serious and what's not serious. And we could have a fun and rousing debate about whether certain types of crimes should be always treated as, serious enough to warrant a jury. But again, like, in times to come, as certain types of trial become more and more complex, we may not think it's a good idea for certain sophisticated fraud cases to have juries, which is exactly the way that's been going in other jurisdictions. But the problem is the charter forces that. And again, alleviates or eliminates, in most cases, any discussion of whether or not it's possible to limit that right. I mean, in theory, you could create a Section 1 justification to limit jury trials for certain types of crimes, but I guarantee you that, given the strict wording of the charter, that is really going to be hard to do. I do think that over time, the longer this goes on, the more, as a constitutional form of convention, it's going to be difficult to overcome that, whether or not it's a sensible thing. And just to be clear, I am not advocating, and I don't want anyone to think I'm advocating, that we shouldn't have juries in fraud cases. That's not what I'm saying at all. What I am saying is it's impossible to have any debate about whether we should have juries in certain types of fraud or any other cases. We just can't do it because, imagine we ever get to a system just in this country. And again, I'm not saying pro or con, where terrorism charges got very hard to do, or certain type of gang charges became very hard to do because people just refused to sit on juries. There was enough, difficulty in obtaining people who were willing to sit on lengthy jury cases to actually get them on. Well, again, like, the accused is happy to sit back and go, well, I got a right to a jury trial. That's the way it is. So, like, you get your jury together, and the Crown and the system have to scramble to make it work. And again, I don't know if it's the right thing or the wrong thing. I just know there's no possibility of discussing it. And I don't think that is ever the way we want to constrain ourselves with respect to criminal law policy.
Right. And in this article, you consider whether removing, if you could, removing this from the charter would actually be a benefit, because, as you've indicated, it's somewhat arbitrary, 5 years, and you indicated in the article that at the end of the day, what does this right actually give an accused in terms of election? Because the attorney general could come in and say, well, no, we're going to have a jury trial anyway. So at the end of the day, I'm just wondering, what, in your view, does this right provide to an accused?
Well, I mean, it does provide a lot to an accused. I think it provides the accused the choice to have a jury. What you're referring to is one of my biggest bugaboos. It's a case that I really dislike. I think it was wrongly decided in 1989. This is the Turpin case from the Supreme Court of Canada, which decided effectively that the right to have a jury does not include the right not to have a jury. And to me, that's a completely flawed way of thinking. I am really troubled by the idea that the Crown currently holds a form of veto power over the accused's ability to elect not to have a jury in many types of cases. And I think I mean, let me be clear, the Crown only holds that veto right for the most serious types of cases like murder. In most cases, the right to elect is the accused. So when you ask me, what is the accused benefit? I think the benefit is large. The accused gets the benefit of jury or no jury in the vast majority of cases. What I don't like about the way the law is constructed right now is that there are certain types of cases where the Crown holds the ability to veto the accused's right not to have a jury. And I don't think that's the proper way to construct how rights are construed. And I do think that revisiting that particular case that decided otherwise is a good idea.
Okay. So if you had that power to rewrite the charter, would you include any right to jury or any reference to juries?
I think that's a difficult question to answer. I think that like what I'm saying is my theory about policy and why I think it's a bad idea. At the very least, I would make the wording more generic, and I would certainly put I would include, as I did in the article, the right to elect a trial by jury to make it clear that you can say, no, I don't want a jury. So to me, that would be fundamental. And as for the timing, I would probably, I mean, I waver, I go back and forth on this, but I do think the jury is enough of an institution that including a right to trial by jury in a vaguer way might be a good idea. But on balance, I'd be just as happy to lose it as a constitutional right, in the sense that I do think the way in which Section 7 has developed would allow for Section 7 to house some of the principles about jury reform in a way that's either Section 7 or 11D. You could still get the main aspects of what Section 11F contains without necessarily losing the benefit of the trial by jury, assuming you want to keep that.
Right. Okay. So maybe wrapping it into or just encompassing in Section 7 or 11D.
11D, sure.
Okay, so we talked about the love-hate relationship, and certainly that's been my experience in researching this topic. There's a mixture of good and bad, and it's not something, at least in my experience in going to law school, that I remember spending a tremendous amount of time on discussing juries in the course of our criminal justice system, the good and the bad of it. So I've been a little surprised to see some of the criticisms that are attached to jury systems. And some of these are related to this kind of presumption by our courts that juries are representative and impartial. And the Supreme Court of Canada has repeatedly said in a number of decisions that jurors are to be presumed to be competent and impartial. And I'm just wondering if you have any thoughts about this presumption, because to me, it's in reading some of these cases, it's more so just stated without any reference to any evidence of that fact. And just wondering your thoughts on that.
Well, I think it operates as a legal proposition more than an articulated scientific fact. In that, I think that the system needs to function, and for the system to function, it needs to operate on the basis of certain presumptions. So I do believe that that's true, just like that the judge is impartial. Um, you want to have some fun with that particular proposition, go canvass any court in any jurisdiction and canvass the lawyers and ask them whether they truly feel that Judge X on the bench is impartial about a particular type of case. Like every jurisdiction will have lawyers who are upset with Judge X or Y and don't want them on their case. But at the end of the day, the law presumes them to be impartial, and it's going to be hard to have them kicked off, and rightly so, because the system needs to function. That is an operational principle at the core of what we're doing. If we believe that juries exist, we have to believe that juries start as being impartial. And I just will say this. I think there are lots of flaws with the jury process, but I do have some faith in the idea of collective wisdom. Not entire faith, but I do think the idea of having larger numbers on a jury pool is to get rid of some of the problems with impartiality or lack thereof. And I don't think that operates well in every case. In fact, I'm convinced it does not operate well in every case. But as a day-to-day function, I don't believe, I will never subscribe to the idea that juries as a group are inept or juries as a group are partial. I don't think that's true. I don't think the evidence supports that. I think the evidence, what we've seen from jury studies, or that juries have shortcomings and juries can be led astray by certain types of evidence, by certain types of biases, especially racial and gender biases, no question. But the idea that 12 people are poor fact finders or that 12 people are poor at resolving individual prejudices of one type or another, I don't think is borne out. And I do believe that by and large, the wisdom of juries, while overstated, is not completely barren as a principle of the way in which we run our system.
On the other side, there are people who believe that the social science evidence indicates that juries can be partial and will consider, for example, besides the evidence of a case, they'll consider exterior things like the way someone looks, or like you said, gender or race. But you don't think that that is a significant enough issue to get rid of the jury in general?
Well, again, discussing whether to get rid of the jury is kind of academic. You have to realize that part of the problem of this discussion is it's being presented as an either or. You have to consider what the alternative is and consider the advantages and benefits of going with that system. Because I guarantee you, bring any lawyer on this panel, and I'm a part-time lawyer myself. I used to say this to my students when I would talk, and I did teach a course about the jury back when I was in New Zealand. I haven't taught it here, but I did teach a course that had a lot of aspects of the jury on it. And one of the questions I would pose to the students is like, what would you want for your trial? And I said, look, me personally, in an ideal world, if I knew who the judge was going to be and I knew that judge to be a reasonable person, I'd want the judge. But unfortunately, this discussion does not take place in a vacuum. And the sad truth of the matter is, there are a combination of judicial officials on the bench who are less than desirable from the perspective of the accused willing to take their shot on a judge. And again, it is a human system. And the question ultimately comes down to, do you want one human to be hearing your story, or do you want 12? And do you think that those 12 might be more persuaded by what it is you're trying to advance? And I'm going to tell you that was literally my own personal response. I would be like, okay, well, can you tell me who the judge is? Yes or no? No, then I'll take the jury. Because my belief was that with 12 people randomly, you might get a different decision. And the risk of getting a judge who I felt would not take my case with the, I don't know, lack of interest or whatever else you want to call it. Lack of interest is not the right word, but with the perspective that I felt the case deserved was worrisome to me. So the idea that juries are good or bad is not a discussion that can be had in the abstract. The question is, what is the alternative? You want to set up a panel where we have 3 professional triers of fact. I might be more inclined to that. They do that in other jurisdictions. The issue of jury pro, con, yes, no is not a simple one to answer, because it is a question in which it is the nature of the question is framed in part by the alternatives. And I guarantee you, if you go and quiz defense lawyers across this country, people who are tasked with advancing the cases of accused person, and you say to them, jury, yes or no, in all cases, I guarantee you they would vote overwhelmingly in favor of having the jury available, because they know that the risks in certain cases of running it before a judge are very high.
And one article I did read, I don't know if you're familiar with Christopher Nolan. He wrote an article a few years ago about his interpretation of the Section 11F, and including the word "the benefit to" a jury trial. And his article, basically a very concise summary here, but basically the benefit to a jury trial for him meant that juries could maybe consider other things than just the evidence of a case, because they're more in touch to the beating heart of society, if you will. And for him, that was a major benefit of our jury system. And I'm just wondering, you've indicated that, if you didn't know the judge, you would want to go with the jury. And if that comes across for defense counsel, in that they are aware that jurors maybe will consider other things than just the evidence in the actual trial.
I think that's true. And I think that's been borne out time and time again by the cases. And I don't think it happens often. And you're talking indirectly about a principle known as jury nullification, which is not supposed to happen. And yet it does happen from time to time because the wisdom of the people, that's one of the reasons why we're supposed to have juries, because you don't have a system that is effectively, the judicial officials are drawn from the state. And those judicial officials have to come back and do their job every day in the judicial system. For better or worse, jurors don't. They're in there for a one-off. They're doing their responsibility and then they leave. And there is advantage to that. There are advantages. I do believe that I've said this before, that judges and crowns, and I say nothing, this is not to slight them or say that what they're doing is wrong, but it's easy for judges and crowns to become jaded. And they become jaded because the truth of the matter is they hear a lot of bullshit and they hear a lot of lies. And that's the way it is. The difference about juries is they don't. They don't hear this stuff all the time, for better or worse. So the idea that the juries can come in and be particularly outraged by a particular action, like, why is the Crown running this case? Like, why are we bringing this up? That is sometimes what the people say. And if 12 people can come to an agreement that this case should not be run, there is some wisdom in listening to those 12 people. And I think what Nolan points to has been shown many, many times. Like, if you go back, one of the classic examples of this is the decision with Robert Latimer in Saskatchewan. And the Latimer case brings up, where he killed his daughter, who was severely disabled, and he killed her. And I'm not going to get into the rightness or wrongness of what he did. I mean, it was wrong. It was clearly, he was convicted. But what's interesting about the case is, and there are different views about the correctness of this, but I will say this: a jury sat and listened to that case, for weeks on end, and they refused to convict him of first-degree murder, even though it was the most planned and deliberate murder in Canadian history. Like, it qualified legally in every single way, and the jury just refused. They knew what it was, they understood what that meant, and as a result, they refused to impose it. In fact, they asked for leniency on the penalty for second-degree murder. And again, you may disagree with that, but that jury had 12 individuals drawn from a range of society in Saskatchewan. They listened to the case, and obviously they believed that first-degree murder was inappropriate, even though it qualified without question for the definition.
Right. So the jury nullification issue, it's not something that happens often in Canada, but for a jury to consider other factors, do you believe that the unreasonable verdict test that we have in the criminal code that would allow an appeal court to go back and look at the verdict of the jury, is that a potential safeguard in potential jury nullification cases?
Sometimes, like, it'll sometimes capture the issue, but not always. It depends upon whether, I mean, look, they've caught some of those cases, but usually they base those on the idea that the jury shouldn't have been left with a particular defense, or the address shouldn't have made this particular comment. But, certainly where it's an unreasonable acquittal, it's a really high threshold to overcome. So I don't think the appellate courts will always do that, nor do I think they should. But it will certainly capture some cases of unreasonable acquittal, without doubt.
So I just want to go back to some of the social science evidence about prejudicial evidence like jailhouse informants and circumstantial evidence, post-offense conduct and demeanor evidence. And these were some of the elements of the Peter Beckett trial here. And they've been recognized as, not to speak of Peter Beckett's innocence or guilt, but in general for wrongful convictions, as some of the trademarks that you see in wrongful convictions. And judges will often give warnings or restrict the jury, written or oral restrictions to the jury about considering some of this evidence. And I'm wondering if that is sufficient for a judge to give a caution or put a limitation on evidence, versus whether courts should maybe look at allowing social science experts, whether it's psychologists or doctors, coming in to talk about, for example, the issues with memory or eyewitness testimony, whether it's appropriate for a judge to take on that role. Because that's what it seems to me, is that they've kind of taken judicial notice of some of the social science evidence, but they're very reluctant to admit the social science evidence to put that before the jury.
You are now trying to take on one of the most complex questions in the law of evidence, which is the extent to which evidence about things that we know are problematic should be litigated before the jury or not. And there is no easy answer to that question. There just isn't. And the reason there isn't is because this question of getting it right or doing the right thing in an individual case is not divorced from serious questions of trial economy that that cannot be ignored. I mean, they're just, and nor can any of this be divorced from the very problematic decision to continue to let the law of evidence be developed on a case-by-case basis by individual courts? Like, these things do not exist independently of each other. They are very real concerns. And I say that because, just to pick each one of them, in each case, yeah, it might be a great idea to hear all the experts who can opine on a situation. The problem is, we're not at a scientific conference, we're at a jury trial. So for every expert I'm going to say who says A, the other party can find an expert who will say B. And that is just the reality of the world in which we live in. So the idea of whether or not we should turn all these things over to experts is a very real question, or whether we should just let the 12 people decide it based on what they think is right, because they have to come to a consensus. And again, I'm not advocating an opinion either way. I'm just saying at this stage, there are serious costs to doing so. Trial economy is a serious problem. Like, these trials, if every expert was allowed to testify on every presumption that we didn't know something about, these trials would never end. Especially serious ones that are already very, very lengthy. So that is a deep concern. And again, the third part of that concern is that the law of evidence, in my opinion, is a mess. And the reason why the law of evidence is a mess is multifaceted. But I will say that one of the problems with the law of evidence is that we refuse to resolve any questions about the law of evidence on a global level. We just continue to leave it to appellate courts to make decisions that eventually slowly filter their way up to the Supreme Court. The Supreme Court decides something. Maybe it's right, maybe it's wrong. There is just no mechanism. We just don't tinker with the law of evidence in the way in which I think we need to. And frankly, tinker is the wrong word. We've never done it. There has never been a serious overhaul of the law of evidence. So some of these questions about who should do what and how they should be done are great questions that would be great to be posed and studied by experts, but we don't do that in Canada. We've just never done it. We've never, I shouldn't say never, but since the Law Reform Commission was disbanded, we've never looked at big questions about the law of evidence in a serious way. We prefer to just deal with them on an ad hoc basis. So the question you're posing is really a structural question about the way we think about the courts and legislatures and the way we think about, how the law of evidence should evolve. But I don't think there's an easy answer to your question. And I'm certainly not going to weigh in on one side or the other, simply because I think the entire process is a mess.
Sure. This ad hoc basis that we consider some of these issues, Peter, do you think it's more so of a case that, as you said, it's about trial economy, but also just ensuring that our system, as we talked about earlier, is operating smoothly on these presumptions?
I think both of those things are in play. But I do know, and I've had, discussions of this sort on Twitter with other law professors, I do know this, that the more you open up questions of, say, demeanor or, say, circumstantial evidence or, say, identification evidence in a particular case, the more you are asking for those issues to be debated on an individual case-by-case basis. And again, well, the more you do that, the more you're saying, lengthen the trial. Like, that is the ultimate result of saying we need to revisit these cases every time. That is the way in which we do things until we get to a point where we're willing to actually insert rules. And every time the Supreme Court tries to insert rules, it does so, but it leaves a lot of caveats and a lot of wiggle room for cases to divert from that, or certainly to allow people to argue that they should be deviated from. So the lack of a clear and cohesive law of evidence is at the core of many of the problems you're discussing.
And one of the concerns that I've read in a lot of these articles and textbooks is the secrecy surrounding jury deliberations. And my understanding is that this was a law that was passed in the 70s and hoping to, quote, curtail any improper motivation to serve on a jury, end quote. And I'm just wondering if you have any thoughts of whether we should be making deliberations something that the appeal courts could look at. Because to me, and I think to play devil's advocate, if you're in an appeal court and you're looking at whether a jury verdict was reasonable, a big component of that would be what was actually discussed in these deliberations. But I'm just wondering your thoughts.
Pros and cons.
Yeah.
It's like every other aspect of the jury system, pros and cons. In an ideal world, yeah, it'd be great. Let's look at what the jury did. We can see if they contravene the legal principles. We can see how they used evidence improperly. All great. The cons are heavy. I am not convinced that justice is served by a US-style situation in which jurors are interviewed after the fact and say things that raise doubts. Like, it's really difficult to achieve finality in a system where you're constantly, dependent upon what individual jurors say about a particular point. And I think that's troublesome. I also think that, at the end of the day, the jury functions as a collective. And the fact that individual jurors see things slightly differently, but are still willing to reach a particular conclusion is one of the strengths of the system. So picking that apart worries me because, again, it's very difficult. It's difficult enough to decipher what a judge does. And he or she writes reasons, and it's still difficult. Trust me, I argue these cases, and trying to convince an appellate court that what a judge said here means X is not easy to do. So again, the more we open up our system, we have to recognize that yes, in theory, we will get to better results, but the cost of getting to those results is going to be high in a lot of different ways in the way the system evolves. And just finally, the other thing that concerns me is it's already hard to get jurors to serve. Allowing them to speak out, you could create rules about identities and stuff, but it's problematic. It's like it's again, one of the benefits of our current jury structure is you do your job, you're thanked, and you are done. That is the end of the day. Do jurors really want to be deciding on murder cases when, a stray comment that they make or something that they say could be held against them? It's not going to leave them liable because we still have jury protection. But at the end of the day, again, I think that's going to weaken the willingness of jurors. I say this without evidence because I could be wrong, but it seems to me that if jurors know they're likely to be scrutinized with a fine pen, like judges take up the job willingly, right? They understand they're going to be scrutinized. I worry about endless scrutiny of jury decisions. I'm not convinced that would be a pro for justice going forward.
Okay, yeah, because it would certainly open the door to a lot of criticism. I can see that point for sure. The other question I was going to ask you is about some jurisdictions internationally require jurors to give some kind of form of reasoning. So I think it's in Belgium where the jurors actually have to list or they're provided a list of questions and they have to provide, it's usually just yes or no questions, but it almost provides kind of a framework for decisions. And I'm wondering, is it the same? Would your concerns be the same with requiring juries to give a type of reasoning for their verdict, that we would just be opening a can of worms and the costs involved would be just too great?
Less so, and that's done occasionally in Canada. Judges do have the option to use what are called decision trees and ask the jury for formal answers to particular questions, and we've seen that happen, and I'm less concerned about that. You're not asking jurors so much to spell out individual aspects of their reasoning. You're asking them to show the nature of the decision that leads to guilt or innocence in a particular case. So I certainly think in complex cases that is occasionally done, and I don't see it raising quite the same concerns. I mean, again, it doesn't, you still achieve finality because jurors can't speak about it or depart from it after the fact. So I certainly think that is something we could look at, and we could even look into making that a more permanent feature, but I have no other strong feeling on it.
Okay, so I'll shift gears to your other article related to juries about the majority jury verdicts in the Charter of Rights and Freedoms. This is an article from 2006, and I'm just wondering if we could just review that a little bit and just start with the historical precedent for unanimous verdicts, whether has any basis or if it's just arbitrary.
It's got a pretty strong historical basis in Canada. I don't think it's fully arbitrary. I mean, my recollection, it's been a while since I did that research, is that most jurisdictions, the overwhelming majority of jurisdictions historically, used unanimous verdicts. Again, there are some certain ideas about the wisdom of the collective and about achieving unanimity that ensure the legitimacy of the verdict. And that is important. I do think ensuring the legitimacy of the verdict is an important value. And let me stress, I'm actually more ambivalent on the idea of should we have majority verdicts or not than you might think. Certainly after reading that article, I just don't think there has been a case made that we should depart from it. So if you ask me on balance, should we have majority verdicts? I would say no. But my reason for saying no is different from other people's reasons. My strongest reason for saying no would be that we have not made a case to depart from the status quo. There's just no statistical case that I've seen to say this is something that needs to happen. And let me just say, if you ever want to know my feelings about any issue in the justice system, I will say it comes down often to this. Reacting to an individual case is the absolute worst way to do justice policy. So what bugs me about majority verdicts is not whether they're pro or con. It's that we don't really care enough to study the issue. We just like to react anytime we get a hung jury and say, oh my God, we need to change the system, which to me, I will universally react against every time, saying that an individual anecdote does not a statistical case make. So therefore, like on the question of should we do it, I don't have the data to actually make a decision. But I will say this, again, if you allow for majority verdicts, I do think there is always a residual concern about the legitimacy of the jury's verdict. And that, to me, would in the long run have the potential to detract from the jury as an institution.
And certainly the arbitrariness that I was referring to, maybe I should have been clearer. I was wondering more about having 12 people coming together and where this number 12 comes from and why it has to be 12 to get this unanimous decision. Any thoughts on where the number 12 comes from?
Well, it doesn't have to be 12, of course, right? We know that. The criminal code allows for it to drop to 10. So, I mean, 12 is not a sacrosanct number. I probably should recall the reason for why it's 12. I remember it being more like 12 is not a particular magic number. I believe from my research, and again, it's been a while since I looked at this, that 12 came about more haphazardly than you'd imagine. And again, I don't think there is any particular magic to 12. I think 12 is regarded as a big enough number to allow for a collective decision. But as to what the magic number would actually be, I don't think there is an answer to that, which is why the code now recognizes that 12 is not always going to work and allows it to drop to as much as 10, figuring that that's a big enough number to work. So again, the idea of 12, whether it was 12, whether it was 15, whether it was 10 or 8, is really, to me, not the core issue. And I tend to think it's a bit more anachronistic than scientific.
Okay. And in your article, you discussed to implement a majority system, verdict system, you would have to obviously do a lot more research and show that there's a pressing and substantial need for this. But assuming, I tried to look to see if there's like stats out there for mistrials, and I wasn't really able to find much in Canada. But assuming we got there someday, what would a majority verdict system look like in your eyes?
So we could create a majority jury system tomorrow. It's not hard to conceptualize or construct, and there are examples from all over the world to draw from. Again, I make clear that to me, the problem with doing so, we haven't even discussed the charter issues yet, but I'm assuming we'll come to that, is justifying the need to do so. But I mean, in terms of doing one, it's not hard at all. Across the world, there are various jury systems. In fact, I believe that Canada is now the last country on earth for which majority verdicts are required in every jurisdiction. I believe we're the last. And I say that, and let me stress that the way in which I put that is very particular, because people will object to that and go, no, there are other jurisdictions. Yes, I am aware of that. Most of the US requires unanimity, but there are states in the US, two at least, where unanimity is not required. Same is true in parts of Australia. It's a mixed bag in Australia. But we are the only nation, the only one, that every jury trial must be unanimous. And that is really something. That's an interesting fact in itself. So like the idea of how we would do it, not hard. We would draw upon most likely the UK or New Zealand experience, and we would recognize that if the concern, and let me stress, again, this is not a statistical concern. This is a hypothetical concern. The hypothetical concern is that good jury verdicts are being ruined by holdout dissenting jurors. We would then decide, well, are we going to, is there a statistical case for allowing for majority verdicts when there's one holdout juror, as is the case, I believe, in New Zealand? Or maybe we should up it to 2 holdout jurors in the UK. And that would be essentially the debate.
Right. And in those majority systems, it's not like a 7-5 split or a 6-4 split. It would be like a 10, like you just said, a 10-1, 10-2 type of thing.
Correct. Sorry, I probably should have made that clear. There is I don't believe there's any common law jurisdiction. There are other jurisdictions that use juries that allow for majority votes, but I'd have to recheck my research, but I don't remember seeing systems of majority rule. Like that, I do not see. I think certainly in New Zealand, where I used to teach, I know that the rule was recommended because of the concern over holdout jurors who were just refusing to discuss and really wrecking the process. So the idea is if you have holdouts, but you have overwhelmingly strong majorities, the idea was that the jury verdict could still be legitimate, even though it wasn't unanimous. And I think that would be the system we'd adopt here. I like it would be a massive leap leap, massive, to go from unanimous to like 7-5 verdicts in this country. And while I will never say never about anything in a criminal justice system, I will say that we are not going to move to that system not only in my lifetime, but in my grandchildren's lifetime. Like, that's how far away we are from any system that's like a 7-5. Like 10-1, maybe. 7-5, never. I just don't see that happening.
And in your article, you talk about the principle of proof beyond a reasonable doubt, and you do mention the charter challenges if Canada ever got to that point of wanting to make this switch. And I'm just wondering if you could just take us through why majority jury verdict may not compromise the principle of proof beyond a reasonable doubt.
Sure. So when I started doing the research, I looked at the two most obvious. I left out Section 7 because I think the Section 7 analysis just overlaps with the other two sections. So I looked at whether or not majority jury verdicts would compromise Section 11D or 11F, because those to me seem the most obvious types of challenges that you would bring against a majority verdict system. So 11D is based on the idea that you have the right to be tried, proven guilty beyond a reasonable doubt. And at first instance, this seems super appealing. It's like, well, how can you be proven guilty beyond a reasonable doubt when somebody doubts whether you're guilty? Like, it seems so logical. And the more I looked at it, the less convinced I was by that form of argument. And I've had this argument with many people, but the more I looked at the studies, and quite frankly, a lot of the studies were done in the US, the more convinced I was that the principle of proof beyond a reasonable doubt has nothing to do with the nature of the jury's verdict. It has to do with the standard of proof that is applied by the jury as a collective institution, and not whether aspects of that jury are coming to a different conclusion in applying the same standard. And the reason I came to that conclusion is because, like, the number of jurors is so arbitrary. Like, the idea, if the proof beyond a reasonable doubt applies to the number of jurors who are voting for a particular conclusion, well, explain to me, for example, how you could ever justify a 10-0 jury verdict. So if you're saying to me, and I've heard this said, well, if we allow for majority jury verdicts, then, for example, an 11-1 jury verdict will lead to a conviction. Okay? Well, that's true. But right now, a 10-0 vote by a jury leads to a conviction. So why can't you just simultaneously argue, but the two other jurors might have resolved against? Like, that would be the argument by the defense. We don't know how they would have voted, but they surely could have voted for innocence. And the problem with all these lanes of arguments is that the number of jurors is arbitrary. Like, why don't we just have 50 vote juror pools and say that if they have 49 out of 50, why is that more legitimate than 10-0? Or less legitimate? And the answer is, it's not. Like, if I were allowed to have the option of juries that have 50 people on them, but I have to get 48 of them on my side, like, why is that more or less legitimate than 10-0? And the more you go into these mathematical exercises, the more you realize that, to use an animal metaphor, you're barking up the wrong tree. I don't think any of this really has anything to do with reasonable doubt. Reasonable doubt is a collective idea. And at the end of the day, so long as all those juries provide for that application of that standard, how individual jurors make decisions doesn't matter, because at the end of the day, the vote is not 10-1, it's one jury in favor of applying the principle beyond a reasonable doubt. And so I don't think the connection between the burden of proof and majority juries is anywhere near as clear as some people would think it is, and as I thought it was before I looked into it. It just seems to me that the argument falls apart a little bit when you start to actually approve the situation. And I would point out, by the way, I forgot to mention, of course, we have historical precedents in Canada of 6 jurors being enough to convict. We don't do that anymore, but in the territories and in Alberta for a long time, it was 6 jurors. Like, again, it's kind of bizarre to assume that 6-0 is enough, but 10-1 isn't. Like, it's hard to work that math, and it's hard to realize that dissent does not necessarily mean that you haven't had the principle applied. And by the way, I could just point out that, of course, we allow for dissent all the time on appellate courts, and I recognize it's not quite the same thing. But imagine, think of all the unreasonable verdict cases that go up to appellate courts, and you get 2-1 verdict. You have 2 judges saying it's unreasonable and 1 saying it isn't. Okay, well, we don't say that those verdicts, which are essentially factual recreations of the burden of proof, are somehow contrary to the charter. because they're not. They're simply different ways of applying the correct burden of proof to a problem. And I don't think that construing a majority jury verdict issue as a burden of proof issue is helpful to resolving whether or not the process is constitutional.
Okay, so just going back to the idea of majority verdicts and talking about the charter concerns, and you can just take me through your 11F consideration.
Sure. So when I dealt with the research, while I was unable to convince myself that Section 11D was a real problem for majority verdicts, I had much more difficulty, or it was much harder to get around Section 11F. And the reason is that Section 11F recognizes the essential right of a trial by jury. And the more I looked at the jurisprudence, the more I found that that was a particular kind of jury. And the question really came down to whether certain aspects of the jury system were fundamentally at the core of what juries do. And it seemed to me that the aspect of unanimity has been recognized in Canadian jurisprudence again and again and again as a core aspect of Section 11F. And I just think that while the courts have never pronounced on it, it would be very difficult to get around the idea that unanimity is a core aspect of our jury system. And for that reason, it seems to me that any attempt to impose majority jury verdicts would contravene Section 11F, which would not, of course, be the end of the day. That's why, when I started this discussion, I said that any attempt to impose majority jury verdicts is going to need evidence. And the reason it's going to need evidence is to mount a strong Section 1 defense of taking away the right to a unanimous jury. One caveat that I'll say about this, and we haven't discussed it in this case, is that it will be interesting to see what the Supreme Court does with the challenge to removing peremptory challenges in the Chohan decision. We know the result in that decision because the Supreme Court said, well, peremptory challenges are not a fundamental part of Section 11F. But I think the reasoning that the court comes to is going to have a lot to say about the potential for majority verdicts, because it seems to me, and let me just stress, I agree with the court. I don't think peremptory challenges are an essential part of 11F. Nonetheless, the way in which the court construes what is an essential part of 11F will have a lot to say about the potential success of any attempt to impose majority jury verdicts.
And in your article, you discussed that how this has become a distinct principle of fundamental justice, and it's kind of taken on that in the jurisprudence. And again, we would need more research and understanding of this issue to mount that Section 1 challenge. And it's a fascinating topic. I know, like you said, it's a long, long, long way away from implementation in Canada, but certainly in the Peter Beckett case, there was a mistrial and it was a lengthy first trial. And we'll never know what the deliberations or what the split was, but something fascinating to discuss nonetheless. Peter, I know we're getting short on time here, but I just wanted to end on if you have any thoughts specifically on Bill C-75 that came into effect in September 2019 related to juries. I know you mentioned earlier reacting to individual cases isn't a great way to make policy, and I'm just curious your thoughts on the bill.
Well, you've pulled my answer. There are different lines of thought about removing peremptory challenges. And I fall squarely in the middle. I'm fairly ambivalent about the change as an individual measure. And quite frankly, I don't think the cases that have been made to keep it based on one theory or another are particularly strong. So I tend to fall more generally on the side of, yes, abolish peremptory challenges because I don't think they do anything. My only caveat to that is I don't think they do anything positive. My only caveat to that is I hate criminal justice policy that's decided on an ad hoc basis. I absolutely loathe it. And this screams of ad hoc policymaking. And as a result, what worries me and where I think the critique about removing the peremptory challenges is more legitimate is we've done nothing to resolve the legitimate claims about certain types of things that peremptory challenges were designed to fix. So let me just say that on balance, I honestly believe, contrary to what a lot of defense lawyers think, that peremptory challenges caused more problems than they solved. I do believe that, and I think getting rid of them was a fine idea. I have no problem with that. However, I do think that there were many situations in which peremptory challenges solved certain problems. And what bugs me is that the government made no attempt to actually redress any of those concerns. They just moved ahead in this ad hoc way and said, we're going to do X. And I've seen that over and over and over again. It is the thing in my lifetime that I am the most tired of, is just watching ad hoc reactionary decision making that gets made on the basis of certain very high level or high profile cases. I've seen it again and again, and it's really bothersome. And frankly, I just think it's the wrong way to make justice policy.
Okay, and certainly the ad hoc or reacting to individual cases in this circumstance is the Stanley case, where peremptory challenges were used to essentially remove Indigenous people from a jury, and a white accused was acquitted of killing an Indigenous male, and then this bill came into creation soon after. Final question for you, just in terms of challenges for cause. Do you think the scope of those needs to be increased now since the peremptory challenges are removed?
I think it's inevitable. If there's one thing I know about criminal justice, it is that every time we push in one way, if we push too hard, the reverberation is going to swing the other way in some form that we haven't predicted yet. It is just inevitable. There is always a pushback. And I think what is going to happen is that removing the peremptory challenges is going to inevitably show certain cracks in the framework. And those cracks will be addressed one way or another. And the most likely way, because it's the most likely power the judges have, it's twofold. Either they're going to make more liberal use of the standby power, or they're going to allow greater challenges for cause. It seems inevitable.
Okay. Well, Peter, this has been a great conversation. And again, I really appreciate your time. If people want to find you on Twitter, do you want to share your handle?
Sure, it's at Peter Sankoff, or they can find me at my website at petersankoff.com.
Well, again, Peter, I really appreciate your time. I can't thank you enough for coming on and sharing your insights. It's been really fascinating.
Sounds good.
All right, Peter. All the best.
Same to you. Thanks for
Take
having
care.
me.